witnessed a sharp increase in corporate and personal insolvencies all over the world. And that is an indication of the things likely to come in the days to come. Such a rare black swan event required a matching response from humanity to save lives that required us saving livelihood, which in turn required saving the lives of the companies. Governments around the world have adopted an accommodative stance, acted swiftly to prevent corporates and individuals from being forced into insolvency and bankruptcy. A range of fiscal, credit guarantee, and monetary and macro-financial measures, such as the moratorium, loan repayments, sector-specific forbearance, infusion of liquidity, credit to financially distressed persons, relief in asset classification in banking norms, etc. Relief from compliance of specific legal obligations have been taken by countries to deal with the economic and financial impact of COVID-19. Now there's a broad consensus that the challenges we face and the key responses we need to meet the challenges to prevent the economies from facing a fate like the Great Depression. There's a broad consensus that the measures are required to be implemented in 3 phases to help the economy transition smoothly towards the positive side of the graph. In the first phase, copious interim measures need to be taken to halt insolvency and debt enforcement activities. These aim at preventing viable firms from being prematurely pushed into insolvency. This includes measures to increase the barriers to file insolvency proceedings. In the second phase, when we anticipate a huge wave of insolvencies, firms that will not survive the crisis without going through an insolvency, this requires addressing by transitional measures such as special out-of-court workouts, establishing informal out-of-the-court or hybrid workout frameworks, facilitating businesses through bridge financing, extending procedural deadlines for a limited period of time. The third phase calls for a regular debt resolution tools to address the remaining debt overhang and support economic growth in the medium term that aims to address mostly the individual financial distress. These measures include implementing a modern consumer bankruptcy regime, insolvency regime, ensuring there are flexible options for debt resettling and repayments, and maybe also debt forgiveness mechanism or discharge, which is we call fresh start process. The government of India has taken several measures to ameliorate the pains emanating from COVID-19, particularly the actions in the first phase are mostly done and maybe ahead of other countries. And the work has begun on second and third stages. The first day, the day before the first lockdown on 25th March 2020, the government of India increased the threshold for initiating insolvency proceedings. As I told, increasing barriers to initiate the proceedings from 1 lakh to 1 crore to prevent MSMEs from being pushed into insolvency. As you know, with this COVID in place, every firm, every industry, and every economy is reeling under stress. The likelihood of finding a white knight to rescue a failing firm is remote. If all failing firms were to undergo insolvency proceedings, most of them may end up with liquidation for want of saviors to rescue them. And upon such liquidation, firms would have a premature death, while assets would have a distressed sale. Rescuing the lives of firms being the prime objective of the code, it needed a course correction at this time to save the lives from being liquidated prematurely. So this situation called for a choice between 2 competing policy options. namely suspend the operations of the code or continue its operations as usual. If you suspend the code, the market would fail to liquidate an unviable firm. This is not good for an economy, but this can be rectified in the following quarter or following year. If the second option is exercised, the market would liquidate a viable firm forever, which can never be rectified. Rescuing a viable firm is therefore far more important than failing to liquidate an unviable one. Further, firms which are failing today solely on account of COVID-19 may bounce back on their own as soon as normalcy restores. Alternatively, they would at least recalibrate their operations and businesses to an all-new normal. So the choice therefore fell on the first option, within time for firms and furthers the objectives of the code. So the first option has further two sub-options, namely suspend the code in entirety or suspend some elements as may be necessary. So the first option would not allow liquidation of a failing firm, whether it was unviable before the COVID or became unviable on account of it. It would also not allow rescue of a failing firm, even if it were viable before the COVID or remains viable despite it. Therefore, the policy should protect those firms which are victims of pandemic and not protect the undeserving. The choice fell on the second sub-option, which suspended only such provisions of the code for such purposes and for such period as are necessary under the circumstances, avoiding any unintended consequences. So contrary to the general belief that the code has been suspended for a year, actually it is a keyhole surgery that suspends a tiny part of the code. It suspends filing of applications for initiation of insolvency proceedings against a company for any default arising during COVID period, which begins from March 2020. Initially, it was thought of 6 months. It has been made 6 months now, and it can be extended another 3 months depending on the need. So this insulates a company which did not have a default as on 25th March, but commits a default during COVID-19 period from being pushed into insolvency. This law does not absolve the company of the COVID default even. It protects some insolvency proceedings, but it does not does not ignore that it is not a default. It remains a default for all purposes except for initiating proceedings. And it also clarifies that applications can be filed for initiating insolvency proceedings against a company for defaults committed before March 25th or after the COVID period. So it does not suspend the applications which are filed for initiation of proceedings, pending for admission, ongoing proceedings, both liquidation, voluntary liquidation, only, as I told, a very tiny hole surgery. So first part, India had done it and did much early, as I told, even before the lockdown happened. Now the second phase measures are being considered, being talked about, both internationally and in India, is that one is that MSMEs, they have probably suffered the most in the wake of COVID-19, and they are unique in many ways. The typical CIRP style resolution may not be conducive for resolution of their insolvency, and in recognition of their uniqueness, most countries have a special dispensation for their resolution within the insolvency framework. The Insolvency Code Section 240A also enables the central government in public interest to provide a modified framework for resolution of insolvency of MSMEs. Similarly, it is the endeavor of every country to provide multiple competing options for resolution of stress. In India, we have today, there are two court-supervised statutory options, namely the corporate insolvency resolution process under the code and the scheme of compromise or arrangement under the Companies Act. And we have one out of the court option, namely the RBI's prudential framework for resolution of stressed assets. These frameworks provide a guided path for resolution, define the role of stakeholders therein, and confer certain benefits. But a formal framework has a set process, therefore some amount of rigidities, while a market prefers flexibility to work out a tailor-made resolution best suited to its own circumstances, but they still prefer a guided path. Of the formal frameworks available, CIRP is the most comprehensive in terms of parties involved and its scope and strategies for resolution of stress. It offers certain advantages and privileges such as a moratorium during the resolution period, binding nature of resolution plan, clean slate post-resolution, and several regulatory benefits which are not available in case of other options or at least the informal options. But it has certain difficulties, at least that it is not available in respect of all defaults today because of COVID-19. Where it is available, the availability of a resolution applicants is a concern in the wake of COVID-19. So this has two consequences. Either the company remains under stress for too long without any resolution, or creditors seek every other means to recover their dues. In either case, the company may not be able to survive. So this calls for a semi-formal or hybrid option which has an element of informality yet provides a guided path and has sanctity and advantages of a formal process. And the most popular form of such a semi-formal option is pre-pack, which has emerged as an innovative corporate rescue method that incorporates the virtues of both formal and informal insolvency proceedings. It is the preferred hybrid framework because it empowers stakeholders to resolve the stress of a company as a going concern with the minimum assistance of state. It is considered fast, cost efficient, effective in the resolution of stress, with least business disruptions and stigma attached with the formal insolvency process. It starts with an informal understanding, engages the stakeholders in between, and ends with a judicial blessing of the outcome, though the nuances differ across jurisdictions. The insolvency laws around the world provide a variant of pre-pack in addition to regular resolution process. And the third is, usually the insolvency processes enable creditors to realize at least a part of their dues. However, as I just mentioned earlier, the fresh start process that discharges debtors who have an annual income, assets, debts below a threshold, marginalized debtors, and do not have a dwelling unit from the qualifying debts and protects them from coercive action of creditors. The chances of recovery in such cases are low, so low that the cost of resolving the insolvency proceeding becomes an additional burden to either the debtor or the creditor or the state. Fresh start process exists for marginalized debtors in many jurisdictions. The code provides for a court-supervised and insolvency professional assisted FSP. On conclusion of the process, the adjudicating authority passes a discharge order which writes up the qualified debt, allowing the debtor to start afresh, subject to an entry in the credit history. The Insolvency Law Committee has suggested a redesign of FSP frameworks to make it accessible, simpler, quick, and cost-effective. It has recommended three major changes: shift from quasi-judicial process to an administrative process, whereby dedicated debt relief officers oversee the process, issue debt relief order. Second is shift from sophisticated insolvency professionals to less costly insolvency advisors who will assist and guide the eligible debtors. And third is the implementation of the entire process on an online platform accessible from anywhere. So these three things, the small special insolvency resolution framework for MSMEs, pre-pack, and fresh start process, which fit into the second phase just mentioned earlier, second phase of actions to deal with the COVID insolvencies. The work is on all these three fronts in India. We have learned quite a bit from the financial crisis of 2008, which is of course different from what we have today. Then the crisis started from financial sector. Financial sector was stressed, the real sector was not. But the stress in the financial sector seeped into or got transmitted to a real sector. But today, to start with, or at least before the COVID, financial sector was in a good shape, a better shape. Real sector had some issues on internal leverage, but at least the COVID started impacting the real sector fast. And then the real sector impacted the financial sector. So today, the real sector is impacting financial sector as compared to financial sector impacting real sector in 2008. Of the various measures taken at that time in 2008, one of the big lessons was that to keep the financial companies ready for resolution, they must be resilient, they must have their autoimmune system to resolve the stress if they come across. And there is financial stability board which has given a formal framework and which has been adopted in many of the countries to keep the financial companies resolvable should a need arise. I think time has come now. The biggest lesson for us today from this COVID in the space of insolvency is that keep also the real sector companies resolvable all the time, ready for resolution should a need arise. And there are many things that need to be done to keep a company resolvable, because insolvency law, while it enhances the rights of the creditors to seek a remedy, resolve the company and recover through a resolution, the insolvency law works well if the company is resolvable. So I think we should take this lesson and try to keep all real sector companies resolvable for such an unfortunate eventuality. Thank you all for a patient hearing and wish you a great learning experience today. I thank once again the organizers, particularly Professor Biswal, who has almost single-handed organized this conference. Thank you. Thank you all.
Thank you so much, sir.
Thank you.
Now I humbly request Professor Dr. S. Shantakumar, sir, to kindly deliver an opening remark. Professor Dr. S. Shantakumar, sir, Director, Gujarat National Law University, has about 27 years of teaching experience at prestigious universities. He has been a research enthusiast in his areas of specialization, which are international law, environment law, human right law, and constitutional law. He has authored 3 books on environment law and 2 books on human right law, and published a number of research articles on contemporary legal issues in various national and international journals and edit volumes. He has presented papers and delivered keynote addresses in many national and international conferences in India and abroad. Sir, could you please address the august gathering?
Thank you, Ambika. Thank you for that gracious introduction. And distinguished guests for this inaugural session of the International Conference on Insolvency Law and CISG at 40. Distinguished Dr. M.S. Sahu, Chairperson, Insolvency and Bankruptcy Board of India. Ms. Atita Kominder, Head, UNCITRAL Regional Center for Asia Pacific. Mr. Luca, Legal Officer, Secretariat of UNCITRAL. Professor Dr. Mamta Biswal, Dean Academic Affairs of Gujarat National Law University and Head GNLU Center for Corporate and Insolvency Law. Mr. K.R. Saji Kumar, Executive Director, IBBI. Members of the center, Mr. Sanjeev Kumar Chaudhary and Mr. Prashant Kumar Tiwari. Distinguished delegates, faculty colleagues, students, invitees, ladies and gentlemen. On behalf of GNLU, I deem it an honor to extend a warm welcome to each one of you to this international conference on this very important theme. This conference is to provide a platform for experts to deliberate upon the emerging legal regime on insolvency and also to celebrate the 40th anniversary of the United Nations Convention on Contracts for the International Sale of Goods, to acknowledge the significant contributions of CISG to international trade by establishing a uniform legal regime for contracts for the cross-border sale of goods. We are well aware that such sales contracts operate as the backbone of international trade, and uniform rules for sales contracts provide traders with an efficient, modern, and comprehensive legal framework to support their commercial activities. Its uniform rules, specifically designed to meet the needs of cross-border commerce, increase the certainty in commercial transactions and decrease their costs. Hence, it is important for us as a law university to recognize and acknowledge the contributions of CISG and UNCITRAL for supporting a sustainable economic development in general and for promoting the cross-border commercial activities. This conference also recognizes the great efforts of the Insolvency and Bankruptcy Board of India for all its efforts to consolidate the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner for maximization of the value of assets of such persons, to promote entrepreneurship, availability of credit, and balance the interests of all stakeholders. Previously, India's corporate regulatory system for the resolution or reconstruction of falling companies and their liquidation were done with the aid of some fragmented laws. In the absence of a well-tailored corporate insolvency and bankruptcy regulation, remaking of falling companies became a very difficult task. This has adversely affected the interest of both creditors and the affected corporate. Sick companies never got an opportunity to exit their business by compensating their creditors. The Insolvency and Bankruptcy Code 2016 was a crucial milestone in this regard and was a catalyst that brought about a change in approach from recovery-oriented solutions to promoting revival as a sustainable solution to financial stress and changing the culture of corporate credit in India. The IBC has overhauled the former Indian insolvency regime, the most notable change being the introduction of a corporate insolvency resolution process, a time-bound process that precedes liquidation and involves financial creditors working together to explore options to resolve the debts of the stressed company in order to enable the company to continue as a going concern. Needless to say, it has inspired other regulatory changes to align financial legislations towards this common objective. As this 4-year-old law evolves, the Indian market continues to explore more innovative means and structures to support the new end game of revival of stressed companies, with liquidation being seen as the final resort. One of the most important developments is, in these trying times, IBBI has given an opportunity for insolvency professional entities to grow into the likes of the Big Four in coming days. It has now broad-based the role of IPEs, insolvency professional entities, by allowing them to provide support services to any insolvency professional and not just the IPs who are its partners or directors of such entities. So the law of insolvency is being harmonized with the global practices. These are early days, and this new piece of law is gradually adapting to our own business environment. What awaits us is a gainful utilization of productive resources to give growth impetus to the economy. I firmly believe that in today's conference, the galaxy of experts and resource persons from various jurisdictions will deliberate on these contemporary issues related to insolvency law and international trade law and come out with some innovative solutions that can guide all of us in discharging our responsibilities very efficiently to attain the objectives for which IBBI was created. On this occasion, I wish to appreciate our Dean of Academic Affairs and Head of the Center for Corporate and Insolvency Law, Professor Mamta Biswal, for organizing such a grand international conference by inviting experts from various countries. I must thank our partners, the IBBI and its chairperson, the UNCITRAL Regional Center for Asia Pacific, and the UNCITRAL Coordination Committee India for graciously supporting this academic and intellectually stimulating event organized by the GNLU Center for Corporate and Insolvency Law. Thanks to each one of you for joining us today in this international conference, and I wish the conference a grand success. Thank you very much. Thank you.
Thank you so much, sir. Ms. Atita Commander is the head of UNCITRAL Regional Center for Asia and Pacific and manages technical assistance and capacity building programs for over 50 states in India, in Asia and Pacific. Along with the same, she also coordinates with the government and international and regional organizations on trade law reform activities and manages programs to promote the rule of law in commerce aimed at achieving the Sustainable Development Goals. Prior to joining the United Nations, she mainly advised and worked on issues relating to law, development, and international cooperation with numerous Thai agencies. She, being an admittance to the New York Bar, has an experience in both common and civil law traditions in public and private sectors. She holds degrees from Harvard College, Georgetown University Law Center, and Harvard Law School. I humbly request Ms. Atita Commander to please deliver an opening remark on behalf of UNCITRAL.
Thank you very much for that kind introduction. Greetings to everyone. Dr. M.S. Sahu, Chief Patron and Chair, Insolvency and Bankruptcy Board of India. Dr. S. Shantu Kumar, Director, Gujarat National Law University. Dr. Mamta Biswal, Dean, Faculty and Academic Affairs Head, Center for Corporate and Insolvency Law, GNLU. IBBI Executive Director, K.R. Saji Kumar. Distinguished speakers, participants, and most importantly, GNLU law students. Greetings from the United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific, located in Incheon, South Korea. I'm Athita and I head UNCITRAL RCAP. First off, on behalf of UNCITRAL and RCAP, I would like to thank our co-organizers, the Insolvency and Bankruptcy Board of India, UNCITRAL National Coordination Committee India, and the Gujarat National Law University Center for Corporate and Insolvency Law, especially Professor Biswal and her team, and the esteemed legal experts on the CISG and insolvency joining us from the Asia Pacific and beyond. I also extend a very warm welcome to my colleague Luca Castellani, or Mr. CISG, of the UNCITRAL Secretariat in Vienna, for joining us so early this morning from Vienna. It is wonderful to virtually welcome both old and new friends to this continuing collaboration between UNCITRAL RCAP and GNLU. As you may know, RCAP is UNCITRAL's only regional center. Its doors opened in 2012, funded by the government of South Korea, and is supported by legal expert secondees from the Korean Ministry of Justice and Hong Kong SAR's Department of Justice. RCAP carries out UNCITRAL's work of promoting the progressive harmonization and modernization of international trade law in approximately 60 jurisdictions in the Asia-Pacific region. RCAP founded UNCITRAL Asia Pacific Day, a series of academic events in the last trimester of the year to celebrate the historical United Nations resolution establishing UNCITRAL in December 1966 and to raise awareness of UNCITRAL to law students and stakeholders. This year, despite the pandemic, a groundbreaking total of approximately 25 institutions of higher learning across 10 Asia-Pacific jurisdictions have joined, enabling UNCITRAL RCAP to engage with a collective audience of over 5,000 to discuss how legal harmonization bridges disparities in national legal systems and facilitate cross-border commerce at a time when the smooth continuation and expansion of international trade are more critical than ever. When trade takes place across borders, legal uncertainty due to the diversity of domestic laws makes the outcome of commercial disputes highly unpredictable and increases transaction costs. One manner of increasing legal predictability is the promoting of the unification and harmonization of international trade law through codification. This is precisely the task that the United Nations General Assembly has assigned to the United Nations Commission on International Trade Law, or UNCITRAL. At this juncture comes the 40th anniversary of the adoption of the United Nations Convention on Contracts for the International Sale of Goods, or the CISG, which the UNCITRAL is celebrating by holding a global series of events under the CISG at 40 initiative. The most successful substantive uniform commercial law treaty in modern history, the CISG has been adopted by 94 states from all regions, economic and legal systems, with Portugal being the most recent. UNCITRAL hopes to see more join from the region of South Asia as well. The predictability fostered by the CISG is well known, as it contains a complete and balanced set of default rules covering the most common issues arising out of cross-border sales. Adoption and use of the CISG contributes significantly to introducing certainty in commercial transactions and decreasing costs, thus facilitating cross-border commerce. It is therefore used as a model for regional and domestic law, and in an increasing number of cases, adoption of the CISG represents an important step towards contract law modernization, to which the domestic enactment of provisions inspired by the CISG follows. The CISG is also used as source of inspiration for other uniform law texts, such as the UNIDROIT Principles of International Commercial Contracts. In addition, the main purpose of the contract is to lay down the rights and obligations of the parties. When the parties are aware of their rights and obligations, they can better comply with the contract, and in the event of a dispute, may find it easier to reach a settlement. If a foreign national law is chosen, a party may not be aware of its content and may incur significant costs in ascertaining its legal position under that foreign law. This makes contract management more difficult and litigation more likely. The adoption of the CISG enhances predictability and can avoid such challenges. The flexibility of the CISG extends to its ability to accommodate new business practices and needs without changing the terms of the convention itself. UNCITRAL's recent texts on various aspects of the law of electronic commerce, including electronic contracting, complement the provisions of the CISG and adapt them to e-commerce practice. It is noteworthy that those texts have already been adopted by about 100 states. UNCITRAL is also conducting exploratory work on legal issues arising from the digital economy. Discussions on smart contracts and artificial intelligence will also include the CISG perspective. The importance of having a uniform default contractual framework for complex cross-border supply chain management has been highlighted recently by the effects of the COVID-19 pandemic. Those contracts for sale of goods under the scope of the CISG could benefit from the application of its Article 79, which clearly specifies the requirements for using non-performance. Parties may further complement that provision by adopting uniform clauses on force majeure, also tailored on the CISG. Moreover, the CISG benefits micro, small, and medium-sized enterprises, the backbone of commerce in most jurisdictions, which may have limited access to legal advice when negotiating a contract. MSMEs are also likely to be the weaker party and therefore may particularly benefit from the applicability of the CISG. Today's focus on cross-border insolvency is also especially timely. As COVID-19 continues to disrupt global trade, the need for harmonization in all legally enabling areas has become more pressing than ever. By way of background, while the number of cross-border insolvency cases has increased significantly since the 1990s, the adoption of national or international legal regimes equipped to address the issues raised by those cases has not kept pace. The lack of such regimes has often resulted in inadequate and uncoordinated approaches to cross-border insolvency that are not only unpredictable and time-consuming in their application, but also lacking transparency and the necessary tools to address the disparities. It is therefore encouraging that a recent case from the National Company Law Tribunal seemed to read the UNCITRAL model law on cross-border insolvency into India's insolvency code framework, which UNCITRAL hopes anticipates or bolsters legislative efforts in India to adopt the model law. Today's conference should be very engaging indeed, and UNCITRAL RCAP is delighted at the opportunity to engage with students, academics, and practitioners of international trade and commercial law from India and all corners. To students in the audience, UNCITRAL in Vienna and RCAP in Incheon have internship application opportunities twice a year. In the coming weeks, RCAP will be accepting applications for our next batch of interns, so please keep an eye out on the United Nations Careers webpage. On that last note, please accept UNCITRAL and RCAP's best wishes for a very successful conference. Thank you very much.
Thank you so much, ma'am. Mr. Luca Castellani is a legal officer in the Secretariat of UNCITRAL. After graduating in law in University of Torino, he received a doctoral degree in comparative law from the University of Trieste and a master in international law from New York University. He joined the Office of Legal Affairs at the Secretariat of United Nations in 2001 and UNCITRAL Secretariat in 2004, where he works in the areas of international sales and of electronic commerce. As Secretary of UNCITRAL Working Group 4, he oversaw the preparation of UNCITRAL Model Law on electronic transferable records. He is also active in the field of paperless trade facilitation and has contributed to drafting the framework agreement on facilitation of cross-border paperless trade in Asia and the Pacific. We're delighted to have you, sir, and I humbly request you to kindly address the attendees.
Yes, thank you. Thank you very much. Good afternoon to everyone. It seems like now I will be able to start my camera, but in the interest of time, I would start speaking. Maybe there is some technical issue here. I do trust that you can hear me well. Firstly, I would like to thank very much the organizers, the GNLU, of course, IBBI, and also the UNCITRAL National Coordination Committee of India for organizing this timely event. Obviously, the common thread of this event is the response to the COVID-19 pandemic. And we see here two very important elements. A discussion that is particularly timely and relevant on the adoption of UNCITRAL texts on insolvency, namely the model law on cross-border insolvency. And I think that there will be many opportunities to discuss the details of this text because there is an ongoing debate in India about the opportunity of adopting this text. That is increasingly relevant and really the gold standard for both developed countries and developing countries. But of course, I was kindly invited here, and I would like to thank him, in particular, Dr. Mamata Biswal, who has been a staunch supporter of the debate around the CISG in India, to share some considerations about the CISG and to the extent possible to introduce also some reflections on the CISG in India. As you know, the year 2020 is the year when we celebrate the 40th anniversary of the adoption of the CISG. Of course, that was the end of a quite long process, but the beginning also of another long and quite satisfying journey. We have now 94 contracting states, And as we say, often they cover more than 80% of world trade in principle. We have decided at Ancestral to set up a series of events called the CSG at 40 to mark the 40th anniversary, and in particular along certain lines, that is to say, to promote the adoption and also the review of certain declarations, but also to promote the use and the uniform interpretation of the text. In that respect, I would like to flag already now the fact that recently we had the accession by Portugal, which was particularly important. This was a discussion that also has been going on for a while. Portugal, like India, was one of the countries that was originally involved in drafting the CSGs, and it was also one of the few European Union member states still missing. So we believe that was quite significant as a step. But what maybe would be very interesting from the perspective of the Indian position is to follow the ongoing discussion in Hong Kong, as there is a public debate about the possibility of extending the application of the CSG from China to Hong Kong, and also where, of course, from a technical perspective, this can be relevant because of the discussion with respect to the operation of the CSG in a common law environment. As I thank my colleague Atita, who very kindly already spelled out the two main functions of the CSG as a treaty and also as a model for national law reform. I think we have also to fully keep in mind the fact that the CSG, as a matter of fact, is the most recent global codification of sales law. And when I say global, I mean codification that has an impact at the global level. So it can be also a national one, but of such importance that the effects spill over across the world. My colleague Atita has also mentioned that there is an effect of inspiration of other uniform law texts. And I would like here to stress that one of the major achievements in the year 2020 was the finalization of what is the joint legal guide to uniform instruments in the area of international commercial contracts with a focus on sales. This is joint because it was prepared by three intergovernmental organizations: the Hague Conference on Private International Law, UNIDROIT, and ANCITRAL. An advanced draft is already available on the ANCITRAL website. It's actually in the 6 languages, but I hope we were actually aiming at finalizing the ebook, at least in the English language, by the end of this year. We will see. We will manage, or it will be early next year. This is an extremely important publication because for the first time, there is a detailed description of how the different texts interact with each other. So you will find there, in particular, the CSG, the limitation convention, the UNIDROIT principles, but also the principles of the Hague Conference on the choice of law in international contracts. And these are, some of these texts are treaties, some are principles, so soft law. There's also reference to the text on e-commerce of ANCITRAL. We know, for instance, India has already adopted the ANCITRAL model on electronic signatures. So it's important there to put the things in context and to give an orientation on how these different texts relate to each other and how they complement each other. Now, maybe the part of my brief contribution that is dearest to my heart is the part that has to do with the position of developing countries vis-a-vis the CSG, and then also the position of India. I I have to say, whenever I discuss with, I am not comfortable with the outcome. Many of the 94 states are developed countries, and this is wonderful, of course. But these countries, they do have capacity, legal capacity, to deal with the issues arising for international commercial contracts. In particular, what we learned from the COVID is the necessity to have a uniform treatment of risk across the supply chains. So from a legal perspective, of course, the pandemic has highlighted the desirability of, first of all, allocating risk clearly across the supply chain, and secondly, allocating it fairly and uniformly. And this, of course, is best done if the same law applies across the supply chain. Many of the ongoing discussions about contracts and COVID are about how to address cases that may have already arisen. I don't think it's appropriate to discuss that. I think what is appropriate to discuss is how to set up an adequate contractual framework so that the parties know exactly who has to do what. And the CSG, in that respect, is one of the best tools, because the CSG has a general duty of cooperation that allows the parties to overcome difficulties and maintain the value that is in their ongoing contractual relationship. So this is really important at the policy level. From these words, you will agree that this is not only relevant for everyone, but is especially relevant for developing countries. And therefore, I'm not so happy when I say that most of the CSG contracting states, not all, of course, but many, are developed countries that belong to the Northern Hemisphere, because that means that maybe also we at the Antitrust Secretariat, we did not put enough efforts in explaining to developing countries all the benefits arising from the CSG, and I would say with very limited, if any, disadvantage. In particular, in Asia, we have regional differences. The CSG is very popular in Northeast Asia. Actually, it was adopted by all Northeast Asian countries, all 6 of them. So Japan, the 2 Koreas, Russia, China, Mongolia. It's very popular in Central Asia and the former Soviet states. It's increasingly popular in the Pacific. It has always been in force in Australia and New Zealand, more recently adopted in Fiji. And very, very interestingly and very importantly, it is increasingly popular in Southeast Asia. For many years, we had the CSG in force in Singapore, where it was seen, however, as a little bit of an academic oddity. The only cases that were citing the CSG were decisions from the Chief Justice of the Supreme Court, who likes to refer to the CSG but in an obiter. And in Singapore, the position of Singapore was really interesting, because colleagues from Singapore would say, the CSG is in force. Of course, we are aware of it. We know how to apply it. If need be, we are ready. But yes, we opt out, which is perfectly fine, because this is an informed choice. But the very important takeaway here is it's not possible to claim expertise in international trade law without being familiar and without knowing how the CSG operates. And it's not possible to opt out of the operation of the CSG without providing the client with full analysis of what are the advantages and disadvantages of opting in another law. The real issue that I would like to raise today, mindful also of time, is why one of the very few, if not the only region in the world, or sub-region in the world, where there is not a single CSG contracting state is South Asia. That's really interesting for me. And maybe this is a question that has to be explored by professors and by doctoral students, but I'm definitely not an expert in this field or in the region. What I do know is that, of course, in India, we have the Sale of Goods Act from 1930. So it's now 90 years old, which is an excellent age, if you ask me. I think we all would like to get to 90 and be in good shape, like that act. But actually, you know, cannot be fit for the needs of the global economy and the digital age. I did check some notes, of course, and I found out that the first time that the Law Commission of India suggested to reform that act was in 1958. So if they did carry out the reform back then, a person born then would retire probably by now. So we are talking about a significant amount of time here and significant discussion. India, as I said, was active in drafting the CISG, and that's wonderful. And I must say also, some 10 years ago, or a little bit more, I had the privilege of coming to Delhi and of discussing this issue, and I did some historical research. And I was told by those who were involved in those days in the front line, that there was a really big expectation that India would be an early country to accede to the convention. And that would happen maybe in the early 1990s, and it didn't happen because sometimes things don't happen, and because some people are busy with something else, the political attention is elsewhere. When we had that discussion on the accession of India to the CSG some 10 years ago, there was general support, of course, and this is important also because obviously India has its own national policy, made its economic choices, and there is also the desire to follow a little bit of an original and modern path, as opposed to keeping legislation that is not only rooted but actually drafted and adopted in colonial times. One criticism that I heard was a criticism about the predictability in the application of the CSG, and the fact that some notions are not defined, and therefore there could be some issues with understanding their exact meaning. Now, I'm sorry, I beg to differ here. We have more than 5,000 decisions on the CSG publicly reported, available for free on the internet. I don't think that by now we can seriously say that we don't know what the CSG says. There's always some slight variation in the application, also because of the facts of the case. But 99% of what the CSG says is very clear. And of course, there is a matter of learning new law when a new treaty is adopted. That applies to each law and each treaty. And that's called continuing legal education. And that's something that lawyers are not afraid of, especially the best ones. So to conclude, if from my very limited perspective, to me, when I look at India and CSG, I can only say it's a match made in heaven. Why it didn't click so far, I don't know. But on the one hand, we have a really important country, both economically and politically. May I say, probably it's difficult to give a ranking, but I cannot think easily now of another country whose accession to the CSG would have the same impact in terms of the message sent out. And we have also there an opportunity to reaffirm the commitment to the international trade law framework, as the CSG is neutral, is well known, is fair, but at the same time it brings predictability and clarity. One element that is very good is that I've seen recently quite a bit of interest from Indian students, and most of them supportive of the adoption of the CSG. And this is really important because in other countries like Brazil or Vietnam, the adoption of the CSG came from the support of the academic community and of the students. CSG was seen as an element of change, of innovation, and the government then followed gladly. Here, of course, I thank the academics, and starting, of course, again with Dr. Mamata and GNLU. They have been a bit of trailblazers here. But I also thank the Ancestral National Coordination Committee of India. I think that they are in the best position raise with the government, and maybe it will be possible to have this discussion in detail and in practical terms. And to conclude, I would like to cite a famous proverb that says, the best time to plant a tree was 10 years ago, and the second best time is today. Now, actually, I should say when we didn't, so now we will plant this tree today. But actually, since I came to India some 10 years ago, I have to say I planted the tree 10 years ago. So now maybe it's the time to reap the fruit. Thank you very much, and I wish you a wonderful and successful conference. Thank you.
Thank you so much, sir. I humbly request Professor Dr. Mamta Baswal ma'am to please brief us about the conference. Professor Dr. Mamta ma'am is working as Professor of Law and currently Dean Academic Affairs at Gujarat National Law University. Her areas of expertise are corporate law, international trade law, and insolvency and bankruptcy law. She is the center head of Center for Corporate and Insolvency Laws at GNLU. She was awarded the prestigious ICSSR Senior Fellowship Award in 2016-17 and has been inducted as an independent women director in Gujarat-based PSUs. She is a member of high-level committee constituted by Ministry of Corporate Affairs for preparation of investigation manual for Senior Fraud Investigation Office. She has published articles on emerging areas of law, specifically corporate laws, corporate social responsibility, and insolvency and bankruptcy laws in various journals and book chapters. Ma'am has participated and presented various research papers on contemporary themes of law in international and national conferences, seminars, and symposiums. I humbly request ma'am to please address the attendees.
Thank you, Ambika. Good afternoon to all present here. Honorable Chairman, Dr. M.S. Sahu, sir, the Chief Patron of this conference. Honorable Director, Professor Dr. S. Santakumar, Gujarat National Law University. Madam Atita Kominder, the legal head, head Ancestral RCAP, and Mr. Luca Castellani, the legal head Secretariat Ancestral, Mr. Saji Kumar, the Executive Director of Insolvency and Bankruptcy Board of India, my colleagues, friends, participants, and the officers from IBBI, Ancestral, and presenters, panelists. A very warm welcome to all of you to this international conference on international sales and CISG at 40 in joint collaboration of Ancestral RCAP, UNCCI, GNLU Center for Corporate and Insolvency Law, and particularly IBBI. So today, while talking about the conference, the two themes which are personally very close to my heart, because the insolvency law, which is a new law, but being a professor of corporate law, I deal with the previous laws also, which were very fragmented in India, starting from SICA to the provisions of the Companies Act. And today we see that the insolvency and bankruptcy code has emerged as one of the promising and dominating law in India in the area of insolvency law. And it is one of the very, very successful law in India. And I think it has contributed to the economy, and even it has raised the standards in the World Bank ranking. So very evident from different points of view. And today, India is in a cross juncture when we talk about both CISG and insolvency laws. So the past 4 years has been very evident that we have been successful in the area of insolvency law, but there are few emerging area as I see when we see the practices in the last 4 years. There are many issues and challenges to the law. but due to this various legislative developments through amendments, through ordinances, through amendments of the regulations, and the unique regulator IBBI coming out with different very effective regulations, I would say, that the law has been established. But at the same time, there is the situation is there are many emerging issues again. So today, the emerging issues like cross-border insolvency, pre-packages, reverse CIRP, then group insolvency. So now today, after 4 years, we see these challenges that how to discuss, how can we incorporate in our law. So these are the background in insolvency law. And at the same time, in cross-border insolvency, I am very happy that India is in a situation to adopt the ancestral model law on cross-border insolvency, because the committees, high-level committees on cross-border insolvency, that they have recommended, I think the first committee headed by Mr. Injit Srinivas, they have recommended to adopt, and the other committee headed by Mr. KP Krishnan already submitted the report, and probably very soon we can foresee that India is going to adopt the ancestral model law on cross-border insolvency. And when we go to CISG, so what Mr. Lucas said, I remember the 2017 when I was pursuing my ICSSR research on CISG and India, why India should be a member by accession. And while taking the interview with Mr. Luca, particularly in the ancestral Vienna office, I was influenced when he stated that for my first question was about CISG, and his statement was that CISG is the most influential and impactful effectiveness. I remember the words international legal instrument. And I am very happy that in 40 years, CISG, I think today 94 countries are member and few are in pipeline also. But Indian position, because my research report has been accepted by the ICSSR, but it is not open to public, and I have to take a permission. Maybe I'll share with Ancestral. And what we see when it comes to the domestic laws, and when the interaction between the international instrument and domestic law is concerned, there are certain barriers in the legal framework of each country. So in some countries, it is very favorable, and in some countries, and I had the opportunity to do the international empirical study in my research, and where I found that it has been a really very successful legal instrument. And because of this reservation clause which is provided in CISG, that countries have the privilege, they have the freedom to reserve some provisions. And in my report also, I have recommended that India also can do the same thing. And the slowly, once the law is clear, then we can also withdraw the reservation. So that is one of the very strong provision in the CISG, which can help in developing the interaction between the domestic law and CISG. And when the membership is concerned, I think in India, our domestic laws, both Sale of Goods Act and Contract Act, and also many cases in the matters of international sales, we are using the different Incoterms and private terms of contracts are there. So it is the high time what Mr. Lucas said, that 10 years back it was a good time and today is the good time. So today really it is a high time that we can be a member by accession, because we cannot ratify. We have to go for accession, and that is why we have chosen these two topics, CISG at 40 while celebrating, what we should look forward, and particularly being a part of in academics in my country. So we thought to discuss this topic extensively, and also insolvency law, which is being a new law, is a very dominating law in the area of commercial and business law of India and the world. So there also we see that when India will adopt the cross-border insolvency, already the expert committee report has suggested few points, basically which are the general concern in other country, like public policy. Then here I think already the recommendation has been made to use the same language of the model law. So like this, our committees have also recommended. But at the same time, we can foresee few other complications. So that is why in this conference, we have one of the round table where 9 speakers from 9 different countries and 1 speaker of India will speak. And specifically, we have provided them the questions, research questions, that whether their country has adopted the ancestral model law on cross-border insolvency, and is it effective? If effective, what are the advantages? Which area they need to change or rectify their law, so that we can also get some inputs from this deliberation, that how those points can help us also in implementing, in adopting and implementing this model law. So with this background, we have structured our the conference, and the technical sessions are basically on the emerging areas of insolvency laws, group insolvency, pre-packages, reverse CIRP, then cross-border insolvency and the model, unsettled model law, and many papers are on model law only, so that it will give some idea that if we are in a very advantageous position now to adopt the model law, but if any issues and challenges we foresee from this discussion, that we can also think about that. Our regulators, our legislature, our the government bodies can look into. Then at the same time, the CISG panel, it is just a celebration, as a lot of literatures are available and various researches are there. But as Mr. Luca said, that in India, the research and this convention, that 10 years back, it was even in UN ancestral office also, I came to know the same thing. And that discussion will help us to understand, but probably this is the high time, because in the last 10 years, many changes have happened in the international businesses and commercial world. So that there, I think today it is the high time that we should think about the CISG. And this is really a very harmonized and unified law, because in my research also I did one a study of 1,000 cases of CISG. That out of 1,000, I found 95% of cases, the national courts are very positive to apply CISG. So that is one in one of my chapter that I will take permission from the ICSSR, and I will also share with all. But there I found, and personally I believe that CISG will help India to be a active partner in the international business forums, and the changes which need to be done in the domestic law, they are very very simple, and we can do wherever we cannot do. What I felt, it is my personal research, so we can use the reservation clause also. That is one option for us. Wherever it will be conflicting with the CISG, then we can use the reservation clause, like particularly this legality of the contract. that was one point which I found where there may be certain issues with our domestic law and CISG. But anyway, it is one of the very successful convention, and when members of the convention is concerned, that happens in a very high level, and the government has to take a decision. And there are a lot of research also on various areas that how our international trade and business will develop. So in that way, these both themes will be very helpful for everyone, starting from academic to the practitioner, that how these two laws are going to evolve in India, because we are in the pre-adoption and pre-ratification stage. So that it is very interesting for our country as well as the other participants and presenters from other country. We will learn from their discussions. And with this background, I just conclude that this platform will just provide a to discuss more intensively on these issues and to bring out certain solution to in these two area through this panel and roundtable and technical sessions. So we'll see tomorrow, and what are the results we will share with each other. And I thank the Ancestral RCAP and Ancestral Affairs, and also particularly Insolvency and Bankruptcy Board of India, the Honorable Chairman Dr. M.S. Sahu sir, for approving this permission to go for this joint collaboration program. And Madam Atita and Mr. Luka, I really I am thankful to both of you, and also UNCCI. One of them is my student alumni, and the other members, Viswanathan sir, all are cooperating, and I'm very much thankful to everyone, and particularly our director, Professor Dr. S. Santakumar, for his support and encouragement, freedom given to us to work for this center. Thank you very much. Again, I welcoming to this conference. I conclude my address. Thank you so much.
Thank you so much, ma'am. Mr. K.R. Sajikumar is the Executive Director at Insolvency and Bankruptcy Board of India. Previously, he has also served as Joint Secretary at Ministry of Law and Justice, wherein he was heading the legislative group, the legislative department that deals with ministries such as finance, corporate affairs, parliamentary affairs,
Ambika,
rural development,
if I can
atomic
intervene,
energy.
can I intervene, Ambika?
Yes, sir. Sir, can I just briefly introduce you?
Thank you for that introduction. I think we are actually running out of time.
Sure, sir.
For your initiative to introduce me. Of course, in fact, it's my duty to thank each and every one of you. Dr. Mamta Biswal has already thanked the gathering, the virtual gathering. But as a matter of custom, it's my duty to express my gratitude on behalf of IBBI to the Ancestral National Coordination Committee India, the and of course it's and spread awareness about the insolvency and bankruptcy code and the processes. Of course, the pandemic has affected all of us, the whole world. It has also affected physical engagement, but I think we at IBBI have made use of the virtual platform, and we have been using it throughout the lockdown period. Let me first of all thank Dr. M.S. Sahu, our chairperson. He has referred to the various measures taken by the government as well as the Insolvency and Bankruptcy Board of India to deal with the pandemic and to ease out the business processes that were actually the pandemic. Governments and regulators can do certain things to help businesses to come to normalcy, but I think it is for the individuals and businesses to find out and reinvent new business models, sustainable business models. Or businesses have been affected by pandemic. I think new business models are emerging, and some of them would sustain in even after the pandemic. Dr. Sahu also talked about resolvability of insolvency. It is very relevant, and I think this, considering the present times, this aspect will be much discussed by the stakeholders. Thank you, sir, for your kind inaugural address and for supporting this program. Next, Professor Dr. S. Shantakumar, Director, GNLU, he in fact emphasized the need for uniform rules, especially designed for cross-border businesses and cross-border transactions for sustainable economic development. He also mentioned about the pre-IBC era and post-IBC period, and explained how IBC is helping distressed businesses and to get rid of their insolvency. Significant aspect of his speech is he pointed to IBC trigger in changes in other financial laws as well. That is very important, in fact. Thank you, sir, for your kind speech. Ms. Aditya Confident, she's head of Ancestral Regional Center for Asia Pacific. She told us the strategic position RCAP and it's how it is helping the jurisdictions in this region by the Ancestral. This is very important. The position of RCAP is really useful to the jurisdictions in this region. And she also explained the Ancestral's endeavor to handhold and support commercial laws. Of course, this is really commendable work that is being done by the Ancestral. Of course, one of the most important things she upon is the career opportunity Ancestral is providing. I think the students from GNLU would be in a position to tap this opportunity and explore and grab it. Thank you, Ms. Aditya, for speech. Ms. G. Castellani, legal officer, Ancestral Secretariat, referred to the 14th adoption of the Convention on Contracts for International Trade. Of course, CISG, this sale of goods, CISG at 40. Although the treaty is 40 years of age, the 90-year-old law in India is still to catch up with the growing changes. I think we are living in a global village, and no country can exist or grow as a single unit. In times to come, this law, the 90-year-old law, Indian Sale of Goods Act 1930, would also be amended to adopt the changes that are happening in the international trade and commerce. So thank you, Mr. Castellani, for your remarks. Dr. Mamata Biswal, but for her, this program would not have been a success even. Thank you, Dr. Mamata, for your earnest endeavor to organize this single-handedly. We are providing whatever support that is necessary for this program. I hope the participants would enjoy this program. Please make maximum use of this. I thank my colleagues Rajesh and also Rakho for assisting us in convening this as a successful program. I also thank the participants from and outside IBBI, the students of GNLU and other professors and faculty. Thank you once again. Thank you very much.
Thank you so much, sir. I request all the presenters to be ready for the technical session, and all the attendees can join the technical session at 1:30 p.m. and virtual roundtable conference at 4 p.m. And thank you for joining us at the inaugural.
Thank you so much, Sajikumar sir.
Thank you, ma'am.
Thank you, sir.
Good.
Thank you. Sir, you have supported a lot. Thank you very much, sir.
Thank you.
Thank you all. Thank you.
Thank you.